Topic of today is constitution and culture, some considerations. Is a constitution a phenomenon of culture? Is constitution making a cultural creative process? Is constitutional jurisprudence the interpretation and application of the constitution by the constitutional court a cultural process? I would like to answer this question in an affirmative way. Culture, at least in a broad sense, and I'm aware that the question of the definition of culture is a perennial question, a philosophical, sociological question encompassing all areas of knowledge, is everything that is consciously created by man. The opposite is a state, the situation of nature. The transformation of the state of nature into a state of culture is change by man. This is not necessarily about change. The state of nature can also be confirmed, affirmed. If this is done consciously by humans, the result is also culture. The word culture is derived from Latin colere, to cultivate something, that is agriculture. However, it is not primarily about a piece of land to be cultivated, to be converted from a natural estate into cultivated state, into a state of culture, but more generally about the conscious creation of a situation, of a state altered by human will. Law is a cultural phenomenon, including, without doubt, the Constitution. The Constitution is a contrat social, a social contract, as Jean-Jacques Rousseau sees it, in order to transform people living in natural society, that is, in the state of nature, who are born in freedom, into a community necessary for their self-preservation and the accomplishment of common tasks. This is the shaping of the state of nature and thus an act of culture. This act of culture has a great influence on the further development of the created community. Its history is shaped by it, and the community is integrated and consolidated as a result. The people in the community remain free, but are subject to a variety of restrictions of ties through the Constitution. These bonds in favor of the community can only be necessary bonds. This is a consequence of the principle of freedom. The Constitution is committed to men, to human beings. The transition from natural state to the cultural state created by the social contract, that is, by the Constitution, occurs for organizational reasons in order to keep the community functioning, and also for reasons of preserving the status, the values inherent in human beings. The cultural state created by the Constitution is not free of values. It is not value neutral. Rather, it is human-centered, anthropocentric. This means that the fundamental values inherent in a genuine and authentic, on a true constitution, and therefore universal, are affected. Human dignity, the principle of freedom, equality, the organizational form of the community, made by the human beings is also defined by this. This organizational form can only mean the political freedom and self-determination of the individual, that is, democracy. The Constitution is therefore part of culture, not an insignificant part of culture, but a culture that essentially shapes the political order. But the constitution also requires culture, constitutional culture. What can be understood by constitutional culture? This term describes, at least in the German area, something very important. Indeed, a highly a country is said to have a constitutional culture if the constitution is respected, indeed highly valued by the population and by the institutions, and causes citizens to identify with it. However, it is also rather vague and is used with different aims. On the one hand, it means that the precepts of the Constitution dominate people's lives and institutions of the state, that the Constitution is accepted by people as a way of life, that they internalize its values, human dignity, freedom, and equality. The Constitution provides a strong impetus for the integration of the community. The doctrine of integration builds on this idea. Constitution as a common set of values should unite. It should be remembered that in order to integrate a multitude of states, the plan for a constitution for Europe was developed and lasted for a decade before it was partially rejected by the populations of some states, at least under the term constitution, and thus came to an end. Constitutional culture is closely linked to acceptance by society, with a willingness to recognize the ideas of the Constitution as a basic idea in the community and to act accordingly. In this respect, the Constitution also has an educational effect. Ernst Wolfgang Böckenförde, a German jurist, has said that the Constitution cannot provide any guarantees for what it stipulates. If constitutional culture is achieved, it is a guarantee of the Constitution. Only a constitution that is accepted by society can have a lasting, sustainable effect in line with its ideal. Democracy as a basic requirement of political freedom, and thus as a political foundation of a constitution, is only effective as long as it is understood and accepted in its true sense, as the Constitution also means. Only if the cultural value of truth supports the practice of democracy can it flourish. If the truth is destroyed or distorted in favor of a one-sided political advertisement, or cover up one's own mistakes in order to gain a majority of votes, democracy is being abused. Democracy means discussion to achieve the best factual solution of a problem, even if the political perspectives may be different. But this is only possible in an open, objective discussion without shame arguments and misleading representations. Constitutional culture is not only individual and institutional identification with constitutional values and their anchoring in tradition and legal thinking, but is often also used to describe certain constitutional orientations that exhibit certain particularities due to tradition, history, and life circumstances. For example, the constitutional culture of the common law area is often referred to, which relates in particular to jurisdiction, also in a historical context, and which adheres to traditional concepts as developed in the English area and carries them forward, albeit partially modified. For example, the concept of the rule of law, as developed by Dicey in England at the end of the 19th and the beginning of the 20th century, and widely recognized there, is repeatedly referred to in numerous Commonwealth countries. However, as a result of the vehement constitutional debate in the United States of America in the 18th century, a separate conceptual approach has emerged on which the American Supreme Court is based and which is quite contrary to the doctrine of parliamentary sovereignty that prevails in England. The French legal system, which exerted a strong influence on the French-speaking countries of Africa and was expressed, for example, in the concept of constitutional jurisdiction, could also be mentioned as a separate constitutional culture. The name and conceptual structure of the Conseil Constitutionnel, the Constitutional Council, was widely adopted, but has recently been pushed into the background in favor of the model of a separate constitutional court in the sense of Hans Kelsen, which has gained ground in other European countries in particular. In the area of constitutional values, it can lead to misunderstandings to assume a certain constitutional culture that allegedly relativizes the fundamental values of the Constitution. These basic values are universal, as they are linked to being human and are also largely secured, at least normatively and formally, by global conventions. Jurisdiction is increasingly accepting the claim to universality of human rights, which has always been emphasized by the creators of universal human rights instruments. This was also clearly emphasized by the German Federal Constitutional Court not long ago. Only a constitution based on dignity, freedom, and equality as an expression of the culture also creates a cultural state. This is a state that has incorporated the constitutional values into its essence and fills them with life. Occasionally, the constitutional text of a state also states that it is a constitution of a cultural state. In the text of the Bavarian Constitution of 1946, the term cultural state is used. Bavaria, as it is said in Article 3 of the Constitution, is a legal, cultural, and social state. A cultural state is not only a state that regards culture as an important element of society, but in particular a state that respects and realizes human values, which also includes its orientation towards culture. The state must allow art as one of the core areas of culture to develop freely, must not restrict it by regulation, and must promote it to the best of its ability. The cultural state also includes the freedom and promotion of culture in the narrow artistic sense. Art is as an essential but not sole dimension of culture, is a creative expression of individual life. It is the creative expression of the individual himself, herself, his, her personality, and reflects emotion, experience, personal history in the particular form of the work of art. All this implies that art must be free. It is also the emotional and intellectual property of the creator of the artwork, to which only the author is entitled, and whose benefit the creator can skim off economically through a license, but whose content and form of expression is always linked to the creator of the artwork. This means that everyone is entitled to enjoy this work of art, this so-called sphere of influence of the work, the Wirkbereich in German. This sphere of influence cannot be effectively restricted by the state. The freedom of cultural creation is also enshrined in constitutional law. There are special standards for this. If not, it is in any case an essential element of personal rights and general freedom of action. Under no circumstances may the state itself decide what constitutes a work of art and what the freedom of artistic creation applies to. Certainly, there may be objective definition difficulties in borderline cases. Whether something is art or is protected by the freedom of expression or even only by the general freedom of action can still be relevant. Let's take German law as an example. Article 5, paragraph 3 of the Basic Law of the Constitution protects the creation of art, both the creation of the artwork itself, the so-called sphere of work, and the dissemination of the artwork, the bringing of the artwork to the public, the so-called sphere of action, sphere of influence. Article 5, paragraph 3 of the Basic Law does not provide for a legal reservation. That means ordinary laws made by Parliament cannot interfere with artistic freedom or substantially curtail its scope of protection. This means that artistic freedom is subject only to constitutional limits. That is, it can be restricted by other constitutional values, other fundamental rights, or even constitutional principles. In such a case, a balance must be struck between the two conflicting constitutional values, which must be optimized. This means that each of the two or more constitutional constitutional norms should be realized in the best possible way. We call this balancing, using an expression from Konrad Hesse, bringing two or more constitutional values into practical concordance. In our context, we can state that the protection of artistic freedom and the constitutional duty to promote art are important elements of the cultural state. This topic opens up a new question, which is very important, but which I cannot go into further in my brief contribution. In my contribution, I tried to reflect in a concise way on the issues: what is constitutional culture, what is a cultural state, and what is the basic approach of the Constitution to art as an element of culture. I thank you very much for your attention.